Netcasts you love.
From people you trust.
This is TWiL.
This is TWiL, This Week in Law with Denise Howell, Stefan Szpajda, and Matt Curtis. Episode 447, airing December 28th, 2018. Best of 2018. Hey folks, it's nearly the end of 2018, which guess what means you're here for the best of This Week in Law from 2018. Thank you so much for your help in putting together our best of shows every year. Our listeners go to twit.tv/bestof and vote on what they'd like to see in these year-end wrap-up shows. So I'm thrilled at your selections and hope you're thrilled at reviewing some of the things that we found important this year. First up, we're going to talk about the public domain. If you're a fan of Felix the Cat, or possibly the works of Igor Stravinsky, Walt Disney, Virginia Woolf, Picasso, Matisse, MC Escher, and others, you'll have lots to celebrate on New Year's Day 2019 because January 1st marks the first time new material will enter the public domain in the United States since 1998. Mark your calendars for January 25th to party with Creative Commons in San Francisco if you're going to be there to celebrate these new works entering the public domain, and enjoy our discussion about this topic from January 2018. I find this super interesting. One of the reasons we started doing this show back in 2006 had to do with the fact that copyright law had been extended the term of copyright had been extended so far and on two different instances by lawmakers in the United States that very few things were falling into the public domain. And so fair use was becoming much more prevalent, necessary as the internet was evolving and people were forging ahead with creating things that hadn't fallen out of copyright yet. Well, fast forward now to January of 2018 and specifically to January 1st of 2019 next year. That is the date when every book, film, song, and other copyrighted creative work in the United States will fall out of copyright protection under existing law, even with the two copyright term extensions that we've seen from Congress in recent years. And so there's an interesting piece over at Ars Technica by Timothy Lee pointing this out and sort of pondering, well, are we going to see lawmakers race in to keep Steamboat Willie under copyright again, the way that they've done in times past when this was going to happen? And it seems like we may not. Timothy reached out to people at the RIAA and the MPAA, and nobody there sounds terribly interested in lobbying Congress, urging them to extend our copyright term yet again. And Timothy's speculation on that is that it's just become kind of a politically unpopular position to take. Copyright terms are already extraordinarily long. And if we were to undergo another extension, if that were to get debated in Washington by lawmakers, it probably wouldn't be a very popular position to espouse to extend that term longer. So there would be a very low likelihood of them just sort of slipping a copyright term extension by in this age of the internet and in the wake of SOPA and PIPA and the outrage that we saw and the mobilization that we saw over that. So it may be that on January 1st, 2019, works from 1923 will go into the public domain, and works from each successive year, 24 the following year, et cetera, we'll start to have a more robust public domain. What do you think about all this, Mike?
I think Timothy's article is fascinating, and I totally agree with him. I mean, wow, what a huge cultural shift we've seen here over the last 20 years. You know, as you mentioned, back in 1998, Congress enacted the Sonny Bono Copyright Term Extension Act. It acted to extend a whole bunch of works that were poised to fall into the public domain. You mentioned Steamboat Willie. That was certainly one of the original Disney creations. There were other works by George and Ira Gershwin. You know, the Gershwin estate was a big proponent of the Sonny Bono Act, and so were a lot of other content creators. So it's so interesting to think about the dynamic and how that has shifted, you know, with some of the big technology companies that are, you know, pushing for more limitations on copyrights. Google, for example, I think is a great example. It's interesting to see how this has really shifted in a major way. So I think it's probably accurate to state that we're unlikely to see more extensions happen. And I mean, ultimately, you know, it's the extensions that happen, you know, life of the author plus 75 years, that's a long time. And so I think we've reached kind of the apex of copyright protection in terms of how long it is. So
Timothy Lee actually reached out to the Authors Guild for feedback on his piece or input into his piece. And the Authors Guild came back to him and said, hey, we'd actually like to see it rolled back. We'd like to see Life Plus 50 because our members need to have a robust public domain to create their works as well. So I think it's really fascinating and an interesting sign of the times. What do you think, Margot?
Yeah, I have to agree. I mean, it seems silly to have it even be so long after life, 75 years. I guess the whole point of copyright law is to create a good incentive to write and, you know, create new works. But if the author himself or herself isn't even seeing those returns, then I don't really see the point as a non-legal opinion. It seems like it makes sense to maybe roll it back because unless I don't know of like a seriously good reason to keep it going longer than 75 years.
Right.
Interesting stuff.
Start to have more access to works created in, well, not that we're in the 20th century anymore, but we shortly not too long ago were. So would be nice
Margot,
to.
Margot, you bring up a really good point about the underlying incentives with respect to our copyright laws. Of course, the Copyright Act, you know, the basis for it is in the Constitution itself, which provides that you know, Congress can pass legislation that protects works for limited times, and so, you know, it is supposed to be of limited duration, and the whole purpose and rationale behind copyright is to make sure that authors and creators are properly incentivized. And are we getting to the point, if it went beyond 75 years, that, you know, the incentive piece is pretty much out of the equation? I mean, no one's creating works knowing, oh, I'm going to create this work because it's going to last for 75 years. I mean, it's just kind of beyond everybody's purview. And that was one of the original challenges to the Sonny Bono Copyright Term Extension Act initially was, you know, you've kind of removed this whole incentive. You've basically made it irrelevant by extending the term so long. So it's I think this is a welcome development, and it's going to be interesting and fun to see the works as they lapse, fall into the public domain, and what creative people are going to be doing with those works once they're free and open to the public.
One of the things much on people's minds in 2018 was whether our cars are going to start driving themselves and how they're going to do that. And of course, when a topic is that hot, there's bound to be litigation over it. Did 3 ex-Google employees, including Anthony Lewandowski, steal self-driving car trade secrets and bring them to Uber? With $2 billion on the line and lots of drama in the courtroom, the parties settled this case in February 2018. So anybody who is listening and is a lawyer and is a litigator is probably not too surprised that on the morning of what would have been their 5th day of trial, Uber and Waymo, aka owned by Alphabet, aka Google, have settled their case. This kind of thing happens quite frequently, even when the parties have tons at stake and it seems like they're never going to settle. Once trial starts, things can change. And I think that's what we're seeing play out here. The terms of the settlement, we don't, I think, know the full terms of the settlement, but Uber has agreed to pay Alphabet the equivalent of $245 million in equity. They also have agreed to give Alphabet a 0.34% interest of Uber's latest funding series. So they're both spinning this as they are now partners rather than adversaries. Uber has made some representations that it will never, ever in a million years use Waymo's, it doesn't actually say in a million years, never, ever, but that they're not going to use Waymo's intellectual property now or into the future. So you could interpret that as never, ever in a million years. I would say that's specific legalese that could be incorporated into the agreement. And the claims are being dismissed with prejudice. They are not going to be refiled. So, Mike, we've all been playing along with the trial this week. Were you, like me, unsurprised to see a settlement drop down on us?
Well, yes and no. I mean, I agree with you that this does happen, and it's not an infrequent occurrence by any means. That both sides, see how it's happened to me on one occasion. We settled a case midway through. Hard to know exactly why the parties decided to lay down their arms and as you said, hop into bed together. I mean, it could be that the evidence that one side thought was going to be great maybe fell flat as far as they could tell. Maybe they weren't thrilled with some of the rulings that the judge made. Hard to know for sure. We do know that I think I've got these figures right. Initially, I think Google was looking for close to $2 billion. And then that went down to $1 billion. My understanding is I read a report that there was a settlement offer earlier in the week made for $500 million. And then last night at the close of testimony, it sounds like they started talking about this $244 million or the equivalent thereof. And so that was enough for Uber. So it's fascinating. I'm a little bit saddened that we're not going to see how this ultimately played out and what the jury was going to decide. But this is I think a reminder for both large and small companies alike that when it comes to particularly to technology companies, when you're dealing with digital property and related IP, the due diligence that's necessary, it's paramount to make sure that former employees that have left the employ of a company, that they're thoroughly vetted. You make sure that they're not bringing any IP that could get the acquiring company into trouble. You got to look at when you're acquiring a company to make sure to trace the origins of that company's IP to make sure that you can account for its origins and where it came from, and that company is not going to be tainted with a claim of misappropriation. So it was a fascinating case. I mean, we loved talking about it before on the podcast here. We loved following the case, seeing all the twists and turns. I mean, it was high drama there in San Francisco. And, there was just so many interesting, delicious moments throughout the litigation. I am, like I said, a little bummed that we're not going to see how this ultimately played out.
Well, it certainly has been great to play along with the people who were reporting live from court this week. There have been some amazingly entertaining and dramatic moments. This morning, had the parties not settled, Anthony Lewandowski, the owner of the company that Uber acquired, that allegedly had the trade secrets that came from Waymo and Alphabet, was about to take the stand, or he would have been called to the stand as part of the conclusion of Waymo's case in chief, but he would have taken the Fifth Amendment. So that would have been dramatic. And we didn't get to see that play out. The jury did get to be played. Judge Alsup allowed to be let in. a clip from the movie Wall Street, the famous "Greed is Good" case, which became relevant in the case because of communications between Travis Kalanick and Anthony Lewandowski, and their communications. Just sort of looking at their communications under a microscope was a huge part of this case, and trying to read into the sort of cryptic comments they would make to each other in text or emails, what have you.
Right.
What that meant, whether Travis was telling Anthony to steal trade secrets or not. I think that was a big part of what would have been at stake as this case went on. Any sort of, you were starting to do this, Mike, give some sort of cautionary tales and lessons for future businesses that we can take away from this dispute. Is there anything you want to say about those communications? And certainly a lawyer can't vet every single thing that is going back and forth in the course of negotiating the purchase of a company, which is what was happening here. But it seems like it would have been nice if there had been more oversight.
Yeah, I think that's exactly right, and I think Uber, although it hasn't come out and said that exactly, I think one of the quotes I read is that they wish they would have done things a little differently, which I think is probably a fair statement, and maybe an understatement of the year, that they should have done things a little differently. Yeah, the text messages back and forth between the CEO and Lewandowski. I mean, some of those were, and I'm somewhat paraphrasing here, we better burn the village, was the response. Yep. So it's like, okay, what exactly does that mean? A lawyer on the other side could probably have quite a field day with an exchange like that. But yeah, I mean, I think this is the poster child for the scenario where it can be very difficult to get your arms around, former employees' communications with the CEO. I mean, you got to just be super vigilant and very diligent here. There, as I understand it, there was some report that was that Uber had commissioned from a third party that looked into whether trade secrets or other information may have left Google when Lewandowski left, and I believe this third party came back and said yes, there was some material that was taken. Interestingly enough, when the Uber CEO, or I guess the former CEO of Uber, testified during the trial, he was unaware of this particular report that was issued by this third party. So, yeah, I mean, it's. I think there's a lot of different takeaways, but probably the main one is, look, you just got to make sure that you've got a great team that's analyzing the situation here, and that you're kind of covering all your bases in the acquisition process.
The other thing I'll add to my being unsurprised about the settlement 5 days into trial is I don't think there were legal issues at stake here that either party wanted to establish precedent for. This was a very factually driven case, whether trade secrets were stolen or not. And I don't think that there were any sort of wrinkles in how the trade secret law was going to be applied or interpreted by the court that, say, Alphabet had a huge stake in making sure the case came out the right way and pursuing it all the way through an appellate process, or same thing for Uber. Do you agree, Mike? I
think that's probably right. Things were a little bit opaque here because this was a trade secret case. We don't have visibility into exactly what the trade secrets were. And at times during the trial, the courtroom was cleared so the testimony could be provided with respect to what the trade secrets were at issue. So I think that I think your sense is probably correct. I think the biggest issue here, and from not only my understanding of the case, but also reading some of the commentary from people that were actually in the trial, is even though there seemed to be like a lot of smoke here with respect to what Lewandowski did and his departure from the company and starting Moto, the other company that was ultimately purchased by Uber. One of the comments or stories I read was, look, there's a lot of smoke here, but I'm not sure that there's a lot of fire that they've been able to establish yet that Uber actually misappropriated or knowingly took information that it shouldn't have taken. I don't know if that's an accurate assessment of the case, but I think your sentiment is probably right.
Rob, you are the closest geographically to ground zero of this case. What's the scuttlebutt about this in the Bay Area?
Yeah. Oh my goodness. Just the Schadenfreude of this is so delicious. It's hard to get past that to any sort of real legal question. I think that, talking about cautionary tales here, one of the articles that I think we have in the rundown here about, decoding Travis's kind of bro speak that he uses with the employees and how this like very hyperbolic language has become such a part of tech and sort of the conversation. I mean, obviously shows like Silicon Valley do a wonderful job of parodying, the save the world rhetoric and the, sort of the tech jargon. But there's a lot of this like very aggressive burn the village, mastermind some shit, all this stuff that he throws around, and that did not pay out well for. I mean, I was about to say it doesn't play out well for them. I guess it did play out well because of ultimately how the trial resolved. But I think there's a lesson in that for any time. In trade secret cases or just in communications with new employees, particularly in, say, an acqui-hire situation like this. I mean, speaking like a responsible adult, if you're a CEO, has real benefit. I mean, because a lot of what this case was about the impression that there was something, potentially even criminal going on here, that and a lot of that has to do with just the language that they were using back and forth with each other. And that may be fun and that may be part of what, sort of the culture that you want to create for your company. And certainly Uber has any number of cultural issues that they need to work through generally. But I think that that's a real takeaway for this and really for trade secret litigation generally is that, if it looks like something untoward is going on, that's going to get you a lot further down the litigation road than if it looks like the parties are behaving reasonably. And particularly because it's a tough question. What is a trade secret? What is, general know-how that might come in the head of the person that you're hiring away from a competitor? And, these are tricky questions that are hard to litigate. But I think, looking like you're trying to be respectable and not, wanting a pound of flesh or whatever the heck it was he was saying, probably best for your CEO not to speak that way.
Consistent with the clip you just saw, in 2018, self-driving car tech and law continued galloping right along. And in March, we looked back at how the law of the horse may make a comeback. Here in California, we are just on the verge of having self-driving cars driving around for testing purposes without any drivers involved, human drivers whatsoever. The first permits for this can be issued as early as April 2nd. You can then, if you are a company testing driverless technology in California, you can test with a safety driver, you can go driverless, and you can also get a permit for deployment. So that would be deploying a car without any human being behind the wheel whatsoever. So it'll be interesting here in California to see how that goes. Right now we have 1,000 safety drivers licensed to test autonomous vehicles. But, these rules would render the safety driver irrelevant. You could have cars out there without any human behind the wheel, not from a consumer this is how I'm going to get to work standpoint, but for the companies who are developing these technologies to test them on the open road. So anybody else nervous about this, Mike?
Yes, I'm a little bit nervous, but excited nonetheless.
Yes. The other interesting twist to this is, of course, the federal government wants to be able to regulate in this area, and it is possible that they would enact laws that would preempt things that states like California are doing. But so far, things seem to be stalled at the federal level. So it's not surprising to see California and potentially other states moving ahead and making sure that these technologies are tested and ultimately sold to the public. We had in the rundown last week, I believe it was, and I'm sticking it back in this week because we never got around to it, a really interesting piece in the Journal of Law and Technology from North Carolina, known as JOLT. Old blogger friend of mine, Rick Clow, who's now with Google Ventures, is one of the founders of this journal, by the way, and is quite proud of the good work it does. There is a piece published there on how we're going to play out, how the liabilities are going to fall once self-driving cars are in people's hands and on the roads, et cetera, et cetera. And it's a really interesting piece that goes back to horse liability law, because both horses and self-driving cars make decisions on their own and may misinterpret the signals that they're getting from the environment. And there's actually a body of law that developed, when horses were commonly on the roads that dealt with who's responsible when someone's horse runs amok and does damage. So we could see some throwing back to these rather creaky old decisions on horse liability law in the near future. So keep an eye out for that. Matt, any thoughts?
Yeah, I just think that this is really fun and really interesting. It'd be great to see horse law make its way back. I'm not sure if it's exactly right. I think that the liability is ultimately going to fall on the owners of the company, because I think we've moved on from, so back in the 16th century, we used to sue sticks for falling on people and killing them. You wouldn't sue you literally sue the tree or I don't think we're going back there. So I think that we're going to sue Google or Waymo or Alphabet or however they want to call themselves. And I think that the law is going to go to where the money is, because it ultimately is the best situation for a concept of equity, which I think is fair and good. But if we get some horse law in there, I'm all for it. If any way that Seabiscuit can be mentioned in a brief, I'm a fan.
We're charging out of the gate with the horse law.
Yeah.
Kyle, what do you think?
Yeah, I think the article is it was really interesting. I think it has some interesting lessons as we go forward with the automated driving technology. I think there are two kind of hangups that I have with applying those types of cases to determine liability. In this case, basically the idea of the horse law is that when the disruptive technology that was cars came along, it was incumbent upon the drivers of the cars to be more anticipatory and aware of the nature of the horses as they navigate the roads. But here, the disruptive technology is the automatic cars. And so to say that it's incumbent upon the people in the regular cars to anticipate the disruptive technology, I think is a little backwards, especially when there's bad drivers. And if you apply the ordinary person standard to the general population, there's going to be people who are just chronically terribly at driving and basically strictly liable for their activity. And so then to thrust upon them the need to be anticipating kind of, not doing behavior that might tweak the algorithms of a automatic car, I think is a bit far. And then also just as a practical matter, if a human can anticipate a driverless car, then I don't think that driverless car is ready for prime time. If there's something I can do, if I see a driverless car and I was like, oh, I shouldn't do this one thing because it might mess up the driverless car, if I can predict that, then that driverless car shouldn't be on the road.
Yeah, that's a really good point. Mike, any thoughts?
Well, yeah, I think Mr. Ed would just be thrilled with this discussion.
You would indeed. In March of this year, we looked at how Last Week Tonight's John Oliver was able to troll the vice president by publishing a children's book about the Pence family bunny. Bottom line, if you're a public figure, it pays to trademark your pets' names and register their domain names while you're at it. Vice President Mike Pence has a rabbit. Actually, it's not his rabbit, it's his daughter's rabbit. And its name is Marlon Bundo. And I'm hoping that a lot of our listeners and viewers have been following along with this story as it has unfolded over the week. But on last Sunday's episode of This Week Tonight with John Oliver concluded that the book that Marlon Bundo had published, the actual book that the first book, the original book, that purports to have been written by the vice presidential pet, needed a companion volume. I haven't read the original book yet, but we were talking before the show. We presume it has to do with living where the Pences live and what it's like to be a pet of the vice president of the United States. But one thing, and this was almost our tip of the week this week, before we decided to make it one of our more substantively discussed stories. One thing the Pences did not do before they published this book, and by the way, all the proceeds for both of the books that we are going to discuss here today are going to charity. So that one thing they didn't do before deciding, hey, we're going to raise money in this nice way by publishing a vice presidential bunny book, is they did not trademark the bunny's name. And hence we have the rest of our discussion today, because John Oliver decided it would be quite fun to publish his own book, purportedly authored by Marlon Bundo, the vice presidential bunny. And that book took on a quite different theme. Tiffany, can you tell us some more about this?
Sure. So the original book is about a bunny's life in the White House. And the new John Oliver book is about that same bunny, Marlon Bundo, but this time he's gay, falls in love, and ends up getting married. So slightly different plotline there.
Yes, and some pointed digs. I downloaded the audio version, the Audible book of John Oliver's. I'm not sure if that differs, if it's an abridged version of the hard copy, but it is a children's book that that has some wonderful voice talent involved in presenting the audio version of it. And it takes some digs at Vice President Pence just by its subject matter, obviously, and also by at the very beginning when the bunny is sort of setting the stage for who he is and why he's telling his story. He says that his grandpa is Vice President Mike Pence, and that the book isn't going to be about grandpa because grandpa's not very fun at all. So John Oliver clearly is taking trolling to a next level here. And over the week, Tiffany, what has happened with John Oliver's book?
Well, I think it's risen to maybe #1 in the category, something like that. But it's a huge bestseller, very successful. Oh, there it is. And I think it's beating the other Marlon Bundo book, if I'm correct there.
Mm-hmm.
Yes. And so you took a look early on in the week at the legal issues around this. I mentioned that the Pences declined to trademark the vice presidential bunny's name. Probably not something that anybody would have thought to do before our discussion here today and the events of this week. What is the import of that?
Well, it's interesting they didn't trademark the name. I mean, if they had, there could possibly be some legal claim for the Pences against John Oliver and Last Week Tonight. Now, this wouldn't be a very strong argument, but they could technically argue that John Oliver and Last Week Tonight infringed upon their trademark rights by using their trademark in the title of the book, in the book itself, and in the marketing materials surrounding the Last Week Tonight book. But they didn't, so they can't.
Your post talked a bit about a potential right of publicity claim. Of course, a bunny can't have a right of publicity claim, but a vice president might be able to, especially because he is mentioned in the book. What do you think about the chances of, well, first of all, of such a claim having any merit, and secondly, about such a claim actually being asserted?
So that claim doesn't really have much merit. I mean, Mike Pence is a public figure, and it would be very difficult to prove that they had violated on his right of publicity rights, or his, privacy tort-related rights, like presenting him in a false light, or any of the legal issues surrounding, say, defamation. It's a very difficult standard to prove when you have a public figure, and especially because this book is most likely going to be agreed upon to be a parody, right? It's pretty clear this is a parody, and it's pretty clear they're not actually saying anything intentionally negative or trying to prove something negative about Mike Pence. At least not something that's demonstrably false.
Let me kick this to our own Mike Keys here, and see what you think about the trademark issues and other legal issues involved in this book, Mike.
So it's actually an interesting issue. That the title of the book, the original, is Marlon Bundo's A Day in the Life of the Vice President. So typically, when it comes to registration of book titles, you can't get a trademark registration unless the title is part of a series. So I don't know, maybe there's multiple Marlon Bundo works of authorship out there, but they would have a hard time, I think, getting an actual registration on just the title. Now, if they were using the name for like collateral merchandise and some other things, they could potentially get a registration for Marlon Bundo when it comes to, for use on T-shirts or other types of goods. But even without a registration, setting aside the registration issue, even if you don't have a registration, you can still enforce rights in an unregistered mark. But I agree with Tiffany that at the end of the day, this is a parody, and I think he would ultimately prevail on a parody defense here.
All right, Matt, do you have any thoughts about bunnies and trademarks and dueling books?
So many, but I'll limit it to a few. First of all, if this was the president and not the vice president, we would have already seen the lawsuit in place and many tweets about this. So just a little different character that he's trolling. He should have went after the more responsible person in the White House. But second of all, in copyright law, so it's kind of an interesting analysis that if he wrote it as the vice president under 18 U.S.C. 105 as a federal government employee, he wouldn't have been able to have a copyright on that. It's just probably done in the private sphere in some sense, and I'm not sure what the analysis is there. But is there a similar limitation on government works of trademark? I'm just not aware of that.
Yeah, not that I'm aware of, but you're right. There is the provision under the Copyright Act that says that works of the federal government created by federal government employees in the course and scope of their employment are not subject to copyright protection. So, yeah, very, very good point.
Well, I think to be fair, this book was written by Pence's daughter. I think either his daughter or his daughter in conjunction with some other family members. So it's not Pence himself actually sitting down and writing a book about the rabbit.
Yeah.
The Pences actually handled this with some grace. I believe it was Karen Pence who tweeted 2 books for charity, win-win, something along those lines. So they did not express a lot of outrage or consternation about the fact that John Oliver had basically usurped their category for children's bunny books. Right. So that's a good thing.
I think that was a great response on their part. Sorry,
Yeah.
go ahead.
Yeah, definitely. And hopefully that will be that, and that our legal discussions here are purely academic and sort of fun to think about, what must have gone through John Oliver's and his counsel's minds before they actually decided to unleash this book. At least I'm hoping some of these things crossed their minds. Any final thoughts, Mike, about Marlon Bundo?
I guess the only other thing that could act as an impediment had the Pences wanted to try to register the name is the Trademark Office might have rejected an application for Marlon Bundo, saying that it's too similar to Marlon Brando. That would be a potential basis under the Lanham Act. And I can't remember if Marlon Brando is still alive or not. But and I'm not sure if it matters for purposes of the Lanham Act anyway. But there is a prohibition about registering a name of somebody else, of a famous person, as I recall. So that could have been potentially another stumbling block for them.
Yeah. Stimpy Cat in IRC is speculating on whether a Playboy Bunny book is in the work for other parts of the administration. I guess we'll just have to stay tuned for that. And I wanted to mention the cast of the audiobook, because they really do bring to life John Oliver's book in a pretty impressive way. Jim Parsons, Jesse Tyler Ferguson, Jeff Garlin, Ellie Kemper, John Lithgow, Jack McBrayer, and RuPaul. So something fun to do if you're looking to donate to the charities involved with either of these books. The audiobook is only $1.99. One of the biggest legal developments of 2018 was, of course, the General Data Protection Regulation, the GDPR, which took effect in May in the EU. Dave Eman of Century Global joined us to break down its 260 pages, 99 articles, and 173 recitals. Dave, you work for a company called Century Global, and Century helps companies manage risk with respect to things like the GDPR, correct?
That's right. What we're trying to do primarily is to help organizations understand what they need to do in actionable things to meet the regulations. If you actually look at the General Data Protection Regulations, of course, they're implemented for the European Union. The actual document itself is 260 pages, 99 articles, and 173 recitals. And it's terribly difficult for somebody who's just trying to run a business to understand what they need to do to meet those obligations, and that's what we're trying to do to help.
Yes, well, we're very glad to have you here, because I'm sure that we have lots of people listening who have heard of the GDPR but don't know all of the particulars about it, or find themselves working for organizations who need to be worried about these particulars, or are simply users of the internet and are wondering how this is going to impact them. And it is going to have an impact, I think, on all of us. First of all, I mean, Dave, just give us the 10,000-foot overview of the GDPR and maybe put it into context, since we have a pretty savvy audience here on things related to data and the internet, how it relates to the privacy framework we've previously seen in place in the EU.
Sure. So the main objective of the European Union in enacting these regulations is that people have the protection of their privacy, their private information, as a fundamental right. And so when you share that information, when it's used by somebody for some purpose, you have the right to know that it is being collected, that you have the right to know how it's going to be used, you have the right to know who it's being shared with. And not only that, you have the right to revoke your consent and have that information deleted at some point in the future if that's something important, and to make sure that that data is correct. So these are all things that I think are top of mind for people right now with all of the things we see with the Cambridge Analytica and Facebook and other things and data breaches. People really want to understand what's happening with their data and what their rights are. And in the European Union, they've taken the pretty bold step of saying, we are going to enact a regulation that applies to everybody in the EU and applies to anybody who processes the data of anybody in the EU. And that essentially means it applies to anybody in the world who processes data of persons in the EU, European Union, that they need to meet these regulations. And I think the thing that has really gotten everybody paying attention to it, and I'm sure this was quite intentional, is this is a regulation that has significant teeth in terms of fines. So,
and what are those fines, Dave?
So a gross breach of the highest part of the regulations could result in a fine of 20 million euros or 4% of your company's global revenue, whichever is the higher. So you can imagine that a small company facing a potential of 20 million euros, call that 30 million US dollars, can be obviously threatening to the existence of the company. So that's one thing, but then you look at somebody like Facebook, somebody like Equifax, which I think we've talked about in the past, and you could be talking about hundreds of millions of euros in fines for non-compliance.
Right. So maybe another good starting point before we go into the particulars of how companies have to shift their thinking about handling the data of these EU users. We know what the fines are for non-compliance. Who do they apply to? How big do you have to be, or how small do you have to be exempted from the GDPR? Or is anybody exempt?
There are some specific rules. If you're a company that's larger than 250 employees, then the regulations apply pretty much across the board. For small to medium-sized companies, say less than 250 employees, if your processing of personal data is, quote, not occasional, which means you do it relatively consistently, then you're covered under the regulations. If you include any of the special categories of personal data, and we'll talk about that in a short bit, then you're included as well. So it goes right across the board. If you're doing any kind of regular processing of personal data of EU persons, then the regulations apply to you.
Mike, I'm curious to get your take on this. Obviously, because the EU is such a huge market, people are going to want to do business with EU users and potentially have a physical presence there as well. And so my take on this is that the GDPR is set to become a global standard in how data is handled. What's your take? Do you think that maybe people will just carve out the EU so as not to have to comply?
God, I mean, that's like the $64 million question, right? I think you're right that it seems like, given the geographic swath associated with the EU countries and the population, it just seems like it is forcing almost a global standard here. But, the devil's in the details ultimately, and we'll have to see how this all plays out, I suppose. I don't fancy myself an expert in this particular area at all, but it seems like there's a lot of open questions. For one, I mean, certainly big global, tech behemoths that have physical operations and assets that are in the EU are certainly going to need to comply. But I guess, Dave, one of the questions that I've been thinking about as we near the implementation date is how, as a practical matter, can this be enforced with respect to smaller companies that may be here in the U.S. or elsewhere that don't necessarily have a physical presence or assets in the EU? How do you go about enforcing these regulations on companies like that?
That is a little bit remains to be seen. The way that the implementation of the GDPR actually happens at the details level is each country in the EU is required to enact legislation to implement the rules of the GDPR, and each country is also required to implement or to create, if they don't already have, a regulatory agency who's responsible for enforcement. So what actually happens on a practical level is if there is a breach of personal data of people in France, then the France regulator will actually get involved. And to the extent that a company has no economic interests in France, that it's really just a company that it physically and legally exists in the U.S., it actually remains to be seen how those kinds of regulatory penalties can be enforced. Certainly if that company starts to move a little bit more into anywhere in the EU, then that enforcement arm gets a lot closer. But at a practical level, a lot of it does remain to be seen.
Yeah, good question, Mike. Let's talk first about what companies have to do to comply with the GDPR, and then let's move into talking about how that's going to look for all of us. So you did a great piece on your company's blog, Dave, back in January that is concise and comprehensible, and I commend you because so much of the discussion I've seen of the GDPR makes my head spin, and this one does not. It's Sentry's GDPR guide. So break it down for us. What are we looking at?
Okay, I think the first part is we need to understand what kind of personal data is being protected. So personal data is things like your name, your any sort of identification numbers, location data, and so on. It can also be physical characteristics, physiological things, IP addresses, and so on. So there's actually a lot of data that is potentially personal data. And the main points of the GDPR are transparency, I think, is the first one. Understand where your data is being collected, how it's going to be used, that there's actually a valid legal basis for the collection of data. One of the aspects in the regulation is processing of data is actually only legal under very specific circumstances for specified, explicit, and legitimate reasons, and limited to what's necessary, I think, is another key part of that. So, for example, if you are entering into a commercial relationship with, buyer-seller kind of relationship, there are obviously certain things that are reasonable for you, information for you to collect: name, address, phone number, credit card number, that kind of thing. Your ethnicity, your political values, your, any kind of biometric data, not so much.
Right.
So
let me break in and ask you this, if you know the answer. Let's say you're talking about a straight purchase transaction and you are paying with a credit card. Right. There's a question of whether the vendor's going to keep that number or not. Is that dealt with under the GDPR?
Not specifically, but it can be covered. So the GDPR is, in a lot of cases, not very prescriptive in terms of what you can and cannot do. So if you collect that data, you need to have a reasonable basis for doing so. If you keep it, a reasonable basis for keeping that data is, well, we often have repeat customers, and we save that data to make their next purchase easier. If you do that, you need to make sure that you obtain consent, and that the consent is actually clear in that you are actually going to be keeping that data for those reasons. So the biggest issue in GDPR is it comes back to transparency. That you can collect data that is legitimate for the purposes that you're doing, and there are very specific rights and basis under which you can collect that data. And consent is one of them. There are actually some other ones.
So let's talk first about consent, because that seems to be a huge part of the GDPR. And I want to come back to that notion that there are other ways that you can collect data about EU residents without getting their consent. Is that what you're saying?
Yes.
Okay, so talk about consent first.
Okay, so consent is in the articles of the regulations. Consent must be freely given, specific, informed, and unambiguous, and that the notice that you're collecting information and that consent needs to be at every point where you collect that data. So freely given means that you can't tie consent to something that's unrelated to it. Specific, uninformed, ambiguous means that hiding it in the fine print on page 14 of some terms and conditions is not okay. So you've probably seen a lot of it already where you're entering your personal information and you cannot move to the next step until you click the box that says, I consent to the use of my personal information for this purpose. And so it needs to be unambiguous, that I actually had to go and click something. It has to be specific to the time and place where that data is actually being collected.
So it sounds to me, Mike, like there may be some, we might be seeing some changes in not just the way that contractual language is presented to people, but in the actual language itself, that it's not going to be quite as dense and incomprehensible as we might be used to seeing. Do you agree?
I think that's exactly right. Under what Dave was just mentioning there, wow, it's going to have to be clear and conspicuous, not buried somewhere in a disclaimer or somewhere at the end of a document full of other terms. So yeah, that seems like that's going to be a fundamental change just right there all by itself. Right. Pretty significant.
In April 2018, Joseph James DeAngelo, the infamous Golden State Killer, was found, arrested, and charged because one of his relatives had provided their DNA to a genealogical database. While it's great he was apprehended, we wondered if there should be more oversight or regulation of genealogy databases and DNA sequencing firms. So I have been wanting to talk about DNA and other remains for some time. And we do the rundown for the show a little earlier in the week before the late week news breaks. And we were already going to talk about DNA and other remains. And then it came out that, how convenient for us and the show, and how good for law enforcement and people in California, that a very nasty character seems to have been apprehended, someone that they've been looking for quite some time, in California who's been known as the East Area Rapist and other things. One of these sort of cold cases that folks had kind of given up on finding this fellow. But a determined DA got together with her team and ran some DNA from the crime scenes against publicly available online genealogy databases. And lo and behold, they have arrested someone that they think has a high probability of being this really bad character. His name is Joseph James D'Angelo, the person who was arrested. And this is all good if they feel like they have the right guy and that this guy is going to finally come to justice. Because certainly, if you've been paying attention to the news about this, you know that the things that this serial rapist and killer has been accused of doing are just awful. So the interesting part for us about this discussion and how it segues into our DNA privacy points is the way in which this suspect was identified and apprehended. As I mentioned to you, the law enforcement officers had what they called abandoned DNA from this particular person. The first step, though, was to take DNA from the crime scenes and then run it through. They have not identified which publicly available DNA database they used. And at this point, I should mention that one of those databases, 23andMe, is a sponsor here at the TWiT network. So they haven't mentioned which one they used, but they took crime scene DNA and they must have created, I mean, I'm speculating here, but what seems the most logical thing to me that they did is create a false profile saying that the crime scene DNA was the DNA of a customer of one of these sites, so that they could create a profile and then attempt to match that DNA up with other customers of these sites. And through that process, again, I'm just speculating here, they found family matches and found someone close enough to the suspect's DNA. They found distant relatives of this person, and he was the right age and lived in the area. And then they found abandoned samples of DNA from him once they had identified him. And those were a match. And they tested it twice. Those are a match to the crime scene DNA, and a close enough match that they're now going to go forward and attempt to prosecute him. So I imagine, Camille, that you're as fascinated by all this as I am. Do you think that the people who are using these databases are aware that, when they do a cheek swab or spit in a test tube and send it in, that this kind of thing could be the result?
I don't think people are aware at all. There's actually a story that EFF had tracked, I think from 2015, that was with the Idaho Police Department. And Idaho police had done something very similar. They went through Ancestry.com and they had found a suspect. They had uploaded DNA, found a closely related person, then went through their entire family history to find a suspect. Contacted that suspect, brought him to an interrogation room on a separate crime that they said that he had committed, obtained a cheek swab after like hours of interrogation, and made this guy wait for over a month to figure out whether or not he had actually committed a crime. And so under the terms when this person and his family members had signed up for Ancestry.com, there was a statement saying that Ancestry wouldn't share genetic information with anyone. So they actually had no clue that it was shared with law enforcement, and that this could be done.
Right. We remember that guy. We talked about him on the show back in 2015. His name was Michael Usry, if I'm saying his name right,
Yes.
U-S-R-Y. And he got a knock on the door out of the blue. He was told by law enforcement that they were investigating a crime and they wanted to ask him some questions. He ultimately was questioned by the FBI. They swabbed his cheeks so they could do the match. And as you mentioned, he was on pins and needles for some time before the results finally came back negative, that he actually was a match to the crime scene DNA. Phew for him. But you knew at that time that it was just a matter of time before the other shoe dropped. And this may not be the only time that the other shoe has dropped since then, but it's certainly a high profile case, and certainly this person is someone they've been looking for some time. So it's a difficult issue, I think, because there is no human that's not happy if Mr. D'Angelo, he still has to go through the process and be tried and convicted, but they now have a suspect, and a suspect that they feel is likely to be the person who committed these terrible crimes. And if that person is found guilty and is punished, that's an excellent thing. I don't think there's anybody who would take too much issue with that. But it's how we get there that is a bit problematic. And there are some things we should mention just on the legal front. Particularly, this happened in the state of California. And there are a couple of wrinkles to this that people might not be considering, a few actually. So for one, in 2008, California became the first state to authorize familial line testing. Searches can be requested only when law enforcement has a suspect and the DNA is tested against, now these would be government databases containing samples from people arrested or convicted of felonies. And the California Attorney General says that it has run 192 familial searches since 2007 in 108 cases. So that's not quite what we're talking about here, but it's a close cousin to going to, beyond a government database to a public consumer database. And then another interesting wrinkle is that this the collection of DNA to create these government databases that then can be used in familial line testing, that was found by the Supreme Court in 2013 to be not a violation of the Fourth Amendment. That's something that the EFF weighed in on at the time, was not happy with the decision and how it came out, and sort of forecasted that we could find ourselves in situations where people are being pulled over for a run-of-the-mill traffic violation, for example, and having their DNA collected because they have encountered law enforcement in a misdemeanor or a felony situation. I believe in California you can only have your DNA collected by law enforcement if you are a felon, or if you're part of a felony investigation, or if you're part of a misdemeanor investigation and have a felony record. Okay, so we have those things going on. And then the other thing going on is what these, and I think this is a real can of worms, what these consumer DNA matching sites tell people that they're doing with the DNA, what they actually do with the DNA, and then what they must do if law enforcement comes to them. And I think that these may be different things. As you pointed out, Camille, I don't think that people know exactly what these sites do with the information that they host. I know that people don't routinely read the terms of service. The terms of service oftentimes do spell out that the companies will comply with valid law enforcement inquiries. But it doesn't seem like that even needed to happen here. If someone creates a profile and sort of games their system by saying, "Oh, this is my DNA," but in fact it's a suspect's DNA or a DNA collected from a crime scene, then that's certainly a great way to catch a killer. But I don't know that it's a great way to that maybe they're in violation. Are they in violation of the CFAA, perhaps, Camille, by doing this?
Probably not, because law enforcement actually went on and they created the details of exactly what happened with the Sacramento killer haven't been fully released yet. But there have been some people theorizing that law enforcement went on, created a fake profile, uploaded the DNA, and from there actually just used the systems. The way that the platform's set up to like match and find family members. And so you could potentially argue that the creation of a fake profile is a CFAA violation. However, I don't see a company suing the government for that. And
the government would likely be immune. But it's an interesting thing just to point out that people have been subject to Computer Fraud and Abuse Act claims because they have created fake profiles on social media. But here we have something slightly different from social media, but I think the principle would be the same. You've probably been following the news recently about the first CRISPR babies having been created in China. Babies whose DNA have been modified or enhanced using CRISPR technology. How quickly science fiction becomes science fact. In June, we spoke with author J.D. Lassica about his book, Biohack, which looks at genetically enhanced babies and what can conceivably be done with abandoned DNA. A big theme in J.D.'s book, as he already mentioned, is how you gather together a bunch of DNA that you could put to other useful and marketable purposes. And one way that is pursued in your book, JD, is to go retrieve it from places where DNA has been left in the ground or in a tomb. Tell us about the legal research you did on that and what you learned.
Well, I relied on experts like you, Denise, to sort of steer me in the right direction. I was sort of coming at it cold, trying to figure out, okay, there are a lot of different categories here. You've got living, like Hollywood celebrities who are leaving their DNA behind in different places. Can you legally take advantage of that? There are the recently deceased, so people, celebrities, even like Marilyn Monroe or Frank Sinatra, they've actually got talent agencies that survive long after their deaths, and they're still licensing their likenesses today, but they are not likely to license their DNA. And then you have the long dead legends like Leonardo da Vinci or Michelangelo, people who have been interred hundreds of years ago. And there's actually an interesting kind of legal question for the lawyers out there of, who owns the remains of Leonardo da Vinci today? Is it the church of the church where he's buried? Is it his ancestors 450 years removed? Somebody else? So the question is, what happens, besides from the criminal point of view, if you send a team of grave robbers, and I've got my grave team operator shirt on here. If you send a grave team operators out there to dig up Leonardo's body, after the criminal statute of limitations passes, and the only question is whether you have the legal right to clone Leonardo's remains and clone it for a particular a variety of different traits, whether you'd be allowed to do that or not. And I think it's actually kind of an open question of who's going to stop you from doing that, the state or somebody who's going to have actually standing to stop you from cloning Leonardo. So I don't know, probably some attorney out there listening to this would have a better idea than I, but from a fictitious point of view, it's just kind of interesting to go out there and decide you want to dig up the remains of the most famous legends in history and then let the chips fall where they may after that.
Right. One of the fascinating parts about your exploration of those issues to me was the fact that, laws that we have around grave robbing never anticipated these kinds of concerns. the penalties, there could be penalties for removing someone's remains, stealing someone's remains, and generally they are, but they're not very severe, and they're not looking toward this kind of situation. What were you going to say, Glenn?
Oh, I just think it's fascinating as well. I think the idea that, we are contained in our DNA is one that, for a while seemed kind of silly and fanciful to people in genetics because, of course, we've always made this distinction between, the erector set we're made out of and then what we do with it. But the truth is that so much of what happens to us becomes a part of our DNA. So we have all the DNA we inherited, and then we go through our lives and the moles and age spots and all these things that again at 50 I'm ever more aware of. The traumas we encounter, they're very real and measurable, and they also imprint in our cells. So the DNA of a person, I don't believe for a minute that someone who goes and takes the DNA from a crypt is going to get a copy of that person in a total or real sense, but I am more and more convinced that the thing they get would be scary and might very well be the sort of thing that the dead person would have had an interest in preventing. And, our law is pretty bad when it comes to dealing with dead people because, of course, dead people can't have rights, and you got property-based law, a constitution that really definitely did not envision dead people having interests. So, we just don't have the sort of legal spectacles to think about those interests of the person who's been dead 5 minutes or 500 years, and so we're not going to do a very good job of it. And I think JD is pointing us in the right direction. We have to be more mindful, frankly, of what it is that we could reasonably foresee in the future that we wouldn't want to have happen to us. Honestly, our whole lives are about that now, right? Every time you pick up your smartphone, it's asking you to give permission. And the recent years and recent events have focused so much attention on how many bits of permission we're giving and how all-encompassing they are, so that we leave artifacts all over the internet, all over society and our friends and our lives, data about us we don't even begin to understand. Once you sort of collect all that data, the data that is the footprint of our lives, piece it together, add it to the DNA that you've got, that you've left behind in the crypt, how far really are we from constructing a biological facsimile of a person who's actually alive now? Maybe 200 years, 300 years, I don't know, or maybe it could happen in the next 100.
If you're looking for an example of a current grappling with what can be done with the DNA from ancient remains, well, we know, and we have in our discussion points from today, we've already discussed trying to bring back the woolly mammoth. Others are trying to bring back the dodo. Some archaeologists just want to study the DNA of people who lived hundreds of years ago. And there's a controversy, or at least a discussion, about whether a tiny mummified body that was found in Chile, whether there were any restrictions to studying its DNA. And the journal Genome Research, which published an analysis of that DNA, decided that the mummy was merely a specimen, did not require special ethical consideration, did not legally qualify as a human subject because she is not living. So if, we're going to take into account that there might be things that could be done with DNA other than simply studying how people lived hundreds of years ago, thousands of years ago. We might want to rethink how we regulate and enact laws about that. The other thing that we've mentioned, the other way you can abandon DNA is not merely by dying, but by going to a restaurant and drinking a glass of water and wondering whether your cleanup team is going to prevent someone from taking that glass. I think it's kind of charming that there's a piece in Bon Appetit magazine discussing the murky legal world of the DNA you leave behind in restaurants, etc. We know that abandoned DNA is out there in the world everywhere, and we know that it's being used. We now know specifically, and we talked about this a few weeks ago on the show, that part of the way that they caught the Golden State Killer and various other serial killers throughout the years, but specifically we now have prosecutorial confirmation from the Golden State Killer case that abandoned tissues were used to collect DNA that the investigators needed to tie together all the loose ends in those cases. So this whole notion of the DNA that we leave around us is going to become more and more important, and we're going to need to think about, if you're out in public leaving things, is it like being in public for the purposes of a photograph? We have special laws that protect celebrities in that kind of case, right, of publicity laws that have come in and sort of trumped this overarching privacy framework that we have that says, hey, if you're in public, you're fair game. I would think that we would see a similar kind of legal process develop as we go forward into these brave new worlds of DNA usages, where right of publicity laws don't only protect celebrities, they protect you from being exploited for commercial purposes without your permission. And I would think that abandoned DNA laws might start to look the same way. But right now we have nothing, as far as I understand it. Glenn, is that your understanding as well?
Well, we have mostly nothing. What we have are a bunch of cases where the courts have tried to figure out how to treat genetic material, and more importantly, for the purposes of something like the Golden State Killer, to figure out whether or not there's entrapment involved, whether the materials were legally obtained. I think in that case, they induced someone to spit in a tube, and I don't remember the whole story, but honestly, the question about how you come to leave your DNA is one that is a part of just a mess of bioethics stuff around genes. We for a long time allowed companies to patent DNA that they discovered. So BRCA1, the breast cancer gene, was owned by Myriad Genetics for years until the Supreme Court flipped that one. Many have heard the story of Henrietta Lacks. So this is a movie was made by Oprah, no less, after a book by Rebecca. Frankly, that story took the opposite position, that it was the DNA of a particular person who left some genetic material behind at Johns Hopkins that was responsible for the discovery, and so it should be credited there, at least according to the position that was taken in the book. People are all over the place. ACLU doesn't know where it stands. If you ask any given attorney, the position they take on genetic material is going to generally be determined by what they're arguing for at any given particular moment. There isn't really a constituency on this. And so, we all sort of feel like that we should own, or at least be able to control, most of the stuff we leave behind to some degree, if you ask it that way. But if it's flipped, so that, the stuff that you leave behind could actually implicate you in hurting people in some way, like secondhand smoke does, then everybody wants to disavow their DNA. So we're going to have to create an entirely new way of thinking about this stuff that comes off of and out of our bodies within the next 5 to 10 years for a variety of reasons. I don't think one of the main ones is cloning people. But I do think definitely that the privacy implications of the fact that you can now just take a scientific vacuum cleaner and figure out who did what where, they're massive.
In much of the world, posting a bad review of your vacation experience might well earn you some sympathy, or at worst, some bad karma. For one Lebanese woman traveling in Egypt this year, though, it got her 8 years in prison. This one could very well have been our tip of the week this week, but so you can treat it as such if you'd like. But I guess in tip form, it would go something like, if you are traveling to Egypt, do not complain about your experiences there on social media in any way, shape, or form, because, and this is not the first instance of the current regime in Egypt having a very crackdown mentality about the internet and its uses. A woman named from Lebanon named Mona El Mazbou, if I'm pronouncing her name correctly. She was 24 years old. She was doing vacation tourism in Egypt and didn't have a very good time. And she posted a video where she complained a lot about the country. She complained she was subjected to sexual harassment. She complained about various aspects of the country. She did post an apology for all of this, but that did not prevent government officials from arresting her at Cairo's airport and ultimately, through their legal process, finding her guilty of deliberately spreading false rumors that would harm society, of attacking religion, and of public indecency. She has been sentenced to 8 years in prison. If you're planning your camel and pyramid trip, just be well aware. And a terrible thing that has happened to this 24-year-old woman on vacation. Any thoughts, Stefan?
I thought it was interesting in the article. There was a reference made to the fact that people have always complained about vacations and always had, told their friends about some bad experience they had, and that doing so on a platform like the one she complained on shouldn't change the underlying fact of this is just somebody complaining about their vacation. And first of all, let me be perfectly clear here. I'm not endorsing the arrest of this woman in any way, shape, or form, but I will say that that's a slightly naive view because what the context in which you use technology matters as much as the technology itself. And in this case, a platform that might have a very different impact if it were used in the U.S. or Canada or Europe. If you're in a country as unstable as Egypt is right now, that same platform is going to have a very different impact. And I think to pretend that this is no different than somebody complaining about their vacation, it strikes me as a little bit naive or disingenuous because you have to take the context in which you use technology into account when you're evaluating its impact. And so I thought that was a weird framing in the story about what this woman had done. I think it's a little dismissive of the underlying issue, I think.
Yeah, I agree. But it does, by the same token, I think it behooves people wherever they're traveling to consider, whether their usual social media practices make sense in the context of where they are and what they're doing. Mm-hmm. What do you think, Brian?
It's a pretty horrifying result, after posting a video online to then be sentenced to prison. Certainly she would have had no idea that was a potential outcome of what she did, especially considering that it wasn't like it was in her control to make that video go viral. And I don't think that was probably her intention. I can't imagine posting something online, it getting a lot of attention and being arrested for it when it's just kind of airing grievances. I think it should make us think that, even if we post something, here in the United States about a country like Egypt, would we get, arrested if we then travel to that country for a vacation or for business or for whatever reason? Do we need to be considering everything we post now on social media and what effects it might have if we were to leave the country and go to some other country?
2018 also marked the first time the Internet Archive's Wayback Machine has gotten the evidentiary respect in court that it deserves. In general, getting evidence in a trial is a pretty onerous thing. You have to be able to demonstrate that the evidence is trustworthy and credible. And listener James Russo pointed out to me that there have been a couple of federal court decisions now, circuit court decisions, where documents archived in the Internet Archive in the Wayback Machine have been admissible in court, that they've met all of the qualifications to be admissible evidence in a trial, which I think is really important as we move forward as a society. So much of what counts as something evidentiary probably appeared on the web in one form or another, and the Internet Archive does its level best to keep track of that, even though things get pulled down. So it's probably a good development to know that if you need to look to the Wayback Machine for evidence, there is at least a bit of federal precedent that you should be able to use it. Stefan, any thoughts?
So I've used the Wayback Machine in litigation before. I've never tried to get anything admitted at trial from that archive, but it's a great tool if, for example, you're litigating against a consumer electronics company and you want to see what they had, what they were offering for sale at a specific point in time, and it can be useful just for investigation purposes. I remember the interface being a little unwieldy at the time that I was using it. I frankly, maybe I haven't used it in a while. Maybe it's improved. So maybe you can get that reliability now that was lacking at the time. But the Wayback Machine is certainly a great tool. It remains to be seen, I think, whether it's broadly adopted as an evidentiary database. But it's encouraging to me again that courts are accepting new technologies and thinking substantively about whether or not they're reliable rather than just dismissing them. So it's great.
Yeah. Do you agree, Matt?
Yeah, I don't know anything about evidence, nor had I heard of the Wayback Machine. I do love the name, and it seems like a very, it seems like otherwise you'd have to rely on, some picture that you'd taken or, on opposing counsel to generate their old, consumer product webpage from previously. So it seems like a great neutral setting to get information about what was being said at a certain time in history.
If I could just add one more thing that I just to kind of be a little dweeby about it for a second. The internet is always speaking in the present tense, it seems, because every time you load a website, you're loading it and there it is. It's kind of like that journalistic present tense. And the Wayback Machine allows you to kind of like insert this alternate reality where now you're speaking in the past tense, and there's something just slightly weird about like using the tool, because you go onto it and it's like you're traveling through time, and I don't know, it just try it out sometime. It's very odd to go to a website that you recognize in its current manifestation and look at it in its old manifestation, because you start to notice all the different UI elements and how they've gradually sort of transformed over time, and you've just kind of gone along with it at every stage. It's almost like hearing a song you haven't heard for a while and kind of being transported to a moment in time. So it is a fun little exercise for those of us who spend way too much time on the internet to kind of jog our memories and see what it used to be like.
In October, Josh Landau of Patent Progress joined us to talk about the law and economics of patent trolls and patent trolling. You have a post up on Patent Progress about NPE's non-practicing entities being more evidence that these are, first of all, these are often known as patent trolls, why they're not good for innovation. So for folks who aren't already familiar with all of the concepts I just mentioned, why don't you bring us up to speed on that front, Josh?
Sure. So the basic idea of an NPE, or sometimes you'll hear patent assertion entity, PAE, or patent troll, they all get used in slightly different ways, but fundamentally refer to some company that doesn't make anything, but does make patents that they then litigate and assert against other companies. And their real business model is licensing those patents out. So the question has always been, what's the impact of that? There's nothing illegal about doing it, but is it good for innovation? Do they pay inventors enough to justify the negative impacts or not? And there's a recent paper from a few professors who've been looking at a lot of evidence, and I wrote a bit about it and linked to the paper. It's definitely worth reading, looking at what happens with practicing entities? What happens with operating companies once they've been sued? How do they change their spending on research and development? How do they change their spending on new products? And the answer they came up with is that there's a real negative impact, that these firms generally reduce their spending. They reduce how much they're willing to spend on research and development, which makes sense. If you think there's a risk that your research and development spending is just going to create new risks for you, it ceases to have as much value. So you see this negative impact. The counter question is, well, the NPEs, at least in theory, do pass their money. They have to pay for those patents somehow. So the inventors at some point are getting rewarded in theory. The problem is that theory doesn't seem to play out. There isn't any real marker that NPEs actually pay inventors in a way that generates more innovation.
Right. And then when they get the patents, other people who are attempting to innovate often find themselves ground to a halt by the litigation process.
Yeah. So, by litigation and also by the threat of assertion, and to a sort of a higher level extent, the idea of a blocking patent is that a patent doesn't allow you to do anything. All it allows you to do is prevent somebody else from doing something. So the fact that I own a patent, I don't own a patent, but if I did own a patent, it doesn't mean that I can do what I've patented if somebody else holds a patent on something that I need to do what I patented. So the simple example is if somebody else has patented ham, I could still patent a ham sandwich, but I can't make a ham sandwich without getting a license from the ham owner. What that winds up doing is that if there's a lot of patents in a space, it becomes harder and harder to build on it, to innovate, because there's always the risk that some basic building block has been patented and that you won't actually be able to do anything once you've innovated, even if you go out and seek your own patent.
Right. And I guess one of the answers to that problem is the whole open source movement and having certain intellectual property ideas that are available for use because they're not tied up with patent. That movement has been around for a long time. What do you make of its current health and welfare?
I think the open source movement is, I'm trying to think of how to say this. I think that it's really, at this point, it's proven that it is a viable model. There's no... Different projects may come and go, but the idea that open source is a workable way to develop software is pretty much, I don't think anyone could really argue with that. But that movement still has some problems with patents. The fact that something is open source doesn't necessarily mean that it isn't going to be challenged by a patent. It's something that I think a lot of open source companies think very deeply about. So Red Hat is a CCIA member, and it is an issue that they care about. They worry. There's the blanking on the meaning of the acronym, but the LOT network is a lot of open source companies have participated in, and it's basically a commitment against their patents ever being asserted against open source products, particularly Linux, but in general open source.
Right, because the ham sandwich problem doesn't go away just because you're dealing with something that's been open sourced. If all the patents involved in what's been open sourced haven't been cleared, then you're still going to be in trouble.
Right. There are a lot of the open source licenses have started to think about this issue, so they make sure that contributors to the open source project give an effective license to users of the project. But they can't bind somebody who didn't contribute to the project. They can't bind somebody who didn't participate. And in some ways it's analogous, and I think we'll talk about this a little later, to standard essential patents and how that interaction between contributors to the standard and their patent ownership works.
Right, and don't they make the contributors to the open source project also warrant that their contributions are original and aren't relying on other IP?
I think that's usually more in the copyright context, but and it also depends on the open source project. Some don't make any warranties whatsoever. I think the larger projects are much more careful about it, especially now.
All right, well, I'm sort of veering us away from patent trolls here and whether or not they're good for innovation. Matt, did you take a look at this and do you have any questions for Josh?
Yeah, I think that it's an interesting area. I think that just to broaden the perspective, there is academic debate about the value of patents in general. So the subset of people who aren't practicing with their patents, certainly would come under greater scrutiny. What are some of the structural things that we could do? You mentioned that this is something that buying a patent and then using it as a litigation tool is completely legal. So what are some of the structural ideas that have come about to limit the negative effects of patent trolls or NPEs?
I mean, there are quite a few. One is what's called a working requirement, which is basically just a requirement that in order to assert a patent, you actually have to be doing something with it other than asserting it. You see this to a limited extent in the ITC, in the International Trade Commission, which has a domestic industry requirement. But because of the way that domestic industry requirement is applied at the ITC, you still see some non-practicing entities at the ITC. They can claim licensing activity. The other problem you run into there, and this is a legitimate concern, is universities are non-practicing entities, but they are also generally actual innovators. They're creating their own patents that they then go out and, in some cases, assert, and in many cases successfully. I know the UC system, the University of California system, has a huge licensing program. My alma mater, the University of Michigan, has a licensing program. Wisconsin, a lot of universities license their patents very successfully because they tend to have actually innovative technologies, but they wouldn't qualify for a working requirement. Structurally, I think the biggest issue is really just making sure that the patents that are out there are valid and are actually new. That's the bigger concern. NPEs, a lot of the time, they rely on sort of corner cases. They rely on patent litigation being expensive, which it is, and they rely on that to extract settlement values. And they rely on broad patents that probably shouldn't have issued because they're easier to assert. They're easier to win a case on when the patent is and this is a software patent problem in particular, when a patent is kind of meaningless and you can argue it means whatever you want, it becomes very easy to say that somebody's product does what the patent claims.
So can you quickly just give us, a lot of our listeners aren't familiar with the patent process. Could you give us an overview of it seems like if you're granted a patent, therefore, that's a statement that you've made something new. Can you walk us through how, some patents get through that aren't actually patentable material?
Sure. So the basic process is you go to a patent attorney. They write up an application with some set of claims when the claim is what you actually claim to own. The application, the specification, the long description, all the drawings, those are just to describe information about your patent. So you'll see headlines sometimes about Apple patented this or Amazon patented that, and they'll look at the title, but the title has nothing to do with what they actually claim to own. You have to look at the claims for that. So you take your claims, you go to the office. Sometime in the next couple of years, the office will get back to you, and the examiner will have had a certain amount of time. It depends on exactly which examiner, what the area of technology is, but somewhere on the order of 15 to 30 hours, maybe a little bit more for some really complex technologies, to go out and look for prior art, for documents that existed before your claimed invention that disclose what you have claimed you invented. And the examiner will say, well, I looked, I found this document, and it shows everything that your claim says, so you don't get your patent. And the applicant will come back and say, well, okay, I'm going to change my claims in this way. Or they might say, well, you don't really understand what that prior art reference really discloses, or you don't understand what my claims mean. And that negotiation happens back and forth. But the examiner does have a very limited amount of time throughout this. I have, and I think Stephen has as well, litigated patent cases. I would regularly spend literally hundreds of hours looking for the right prior art to invalidate a claim. An examiner gets on the order of 20 hours to find the prior art and write up their response to the applicant and deal with all the paperwork, which all takes time. So they're getting significantly less time than private attorneys will spend later on. That's a large portion of the reason. Part of it is just resources. They only have so many resources. There's actually, I have a blog post going up soon, hopefully today, on a new prior art archive that Cisco and Google and MIT and the USPTO collaborated on. And the idea there is to provide prior art resources outside of patent documents. Examiners tend to rely on patent documents, but there's a lot out there, especially on the tech side of things, that's product manuals, web pages, standards proposals, all the sort of non-patent but really technically important documentation. So I think the big problem at the patent office is just a resource limit. It's examiners only have so much time. Their job is not that easy, and they have a limit on what they can find. So at the end of the day, there are going to be some patents that slide through because the examiner just couldn't find the art that should have been found based on these restrictions. And in some cases, I mean, examiners are humans. They make mistakes. Some of them try harder than others. And sometimes an examiner will let something through because the applicant just isn't going to take a no for an answer. So there's no way for an examiner to say permanently, okay, this is not going to go. This patent cannot be granted. The applicant can always come back, can always make a new proposal, make a new argument.
In October, video game lawyer Wes Paisley joined us to talk about the fun yet legally hazardous business of real-life Mario Kart. Why don't we talk about real-life Mario Kart? That one's kind of fun, where there is an entity in Japan that decided it was going to take to the streets of Tokyo with real live go-karts and for their customers driving the go-karts, all kinds of costumes. They could decide which Mario character they wanted to be and fly down the streets. And it looks so fun. The author of this piece at JD Supra was sad that driver safety laws did not permit the people participating in this to throw things at each other from their cars. But the fact that this happened at all is sort of delightful until the fact that Nintendo came along and said, hey, you haven't bothered to license any of our IP in putting together this car rally on the streets of Tokyo, and we're going to have to sue you about it. And they wound up having to pay 10 million yen, about $89,000. And apparently they're not banned from letting people drive around on go-karts in sort of a Mario homage kind of way. Well, I guess that's where it would get sticky because the costumes definitely are not going to be allowed. So what do you think about this, Wes?
I'm actually torn because I'm a Nintendo fan, but I understand intellectual property. So I'll just take a moment and simply say, yeah, they should have consulted with Nintendo. And I think Nintendo would have given them a fair deal, maybe an expensive one, but Nintendo understands a lot about brand recognition, especially in their hometown of Japan, and where people are going to love this attraction. And if they thought about other type of rules and regulations, I think Nintendo would go forward with it. But they got to understand, this is Nintendo. Nintendo sues everyone. And when I mean everyone, they sue. People talk about the recording industry where they sue individual people for downloading music illegally. Nintendo sues developers, entertainers. They go after everyone because they understand the importance of protecting their brand. Furthermore, Nintendo, when they first started out in the 80s, got sued by Universal Studios for use of Donkey Kong. They obviously won, and because they found a little niche in the history books that Universal had banned in the use of King Kong, and at the same time, the judge realized King Kong has like a King Kong didn't have like a red tie. So yeah.
Well, I mean, it's interesting you bring up, you can sort of get away with a little bit of this. For example, there is an Australia-based race event called the Mushroom Rally. Of course, people can't trademark or copyright mushrooms, but the association with Mario Kart is so strong. I'm sure the folks participating in the Mushroom Rally know that they are having a Mario car or kart-like experience. And apparently the Mushroom Rally will be coming to the U.S., supposedly coming to Denver per this article. And then there is a championship race in Las Vegas. So Again, I'm sure that Nintendo would look at that closely and try and decide whether there's enough similarity or not to their franchise to come after these people. As you say, they're not afraid to do that. Any thoughts about the Mushroom Rally, Wes?
So this is an interesting one because just by the term Mushroom Rally, that's okay. The question is, what's different is it doesn't seem like they're actually going to be encouraging people to use costumes. If they're really smart, what they'll just do is just call it a race car rally for fans, video game fans, and then they would encourage them to cosplay, which in effect is just the fans' ability to be free to put on whatever they want to, what type of costume. And the organization is not held liable for endorsing a specific type of trademark or infringing off copyright for that matter. But I'm looking at it and I have a sense they're going to be careless about it. So they might fall along some lines of trademark infringement, especially if they're going to put some information in their copy and then not put the trademark symbol. But if they have a lawyer, the lawyer's just going to say, guys, just simply call it a race and then allow people to cosplay, and that'll be fine.
Sounds like great advice. Mushroom Rally. I know a guy in New York you should be talking to if you're not talking to anybody yet. Matt, what do you think?
I think this is great video that they're shooting for this right here. But yeah, I mean, I think that, in terms of the racing on the streets in Tokyo, I'm not familiar with Japan's specific intellectual property laws, but it seems like, at least from the article, that they made the distinction upon whether, the company that was running these races on the streets was giving out the costumes or not. Probably wasn't a good idea to be giving out the costumes, but I feel very differently about people driving around go-karts in the streets of Tokyo, whether or not they're wearing Mario Karts. I'm much more in favor if they're wearing Mario costumes. So, I think it's a fun story of people really loving this video game from, 10, 15 years ago. I don't know if they come out with a new version, but I would probably play it.
Yep. Sounds like a good call. What do you think, Stefan?
So I'm not much of a gamer anymore, but when I was younger, I just loved this game, and I used to say that nobody could beat me at it. And when I was in law school, I knew a guy also named Stefan who thought he could beat me at it. And so there was the showdown of the Stefans at Mario Kart, and of course I won, and it was great. And I think every once in a while I think about this, and it makes me so happy. And it's hard for me to imagine characters with more goodwill than these Nintendo characters, and I think they're so beloved. So I understand why people want to dress up like them. At the same time, I think obviously Nintendo had to do what it had to do here. So I just wish that I had time to put on a Mario costume and sit down in a go-kart and cruise around the streets of Tokyo. That sounds like a great life. If there's a path from where I am now to that, if somebody can clarify that for me, I'll get on that path right now. It doesn't seem to be what the future holds for me, though.
Yeah,
so I'm just glad these people are having fun.
If I were the Japanese government, I would intervene and have a chat with Nintendo because, goodness, what a tourism lure, right? I would plan a whole vacation to Japan around this. Sounds amazing. I can't thank you enough for joining us throughout 2018 for This Week in Law and for our Best of show. We so appreciate our listeners and viewers, and we can't wait to be back in 2019. Continuing to cover everything fun and exciting at the intersection of technology and the law.